The question for today's video, what is a court confirmation sale? So today we're going to define what it is and kind of walk through the process. I'm Kevin Sales, your title rep, and I solve real estate problems before they happen. A lot of people don't understand what is a court confirmation sale and what are the steps involved. So let's walk through them real quick. First and foremost, the probate case is filed with the court, and usually somewhere around 60 days later, the judge will issue letters testamentary. And those letters testamentary will declare who's going to be in charge of the estate. Once that is done, that person has the powers over the estate. And typically when there's limited authority, and there could be some other reasons why, but it's usually when there's limited authority, the party who's in charge of the estate will do a court confirmation sale in order to sell the real property. And on a court confirmation sale, a couple things happen. Usually a couple weeks after that, the court referee, which is kind of like an appraiser, they're going to give their opinion of value. And when they give their opinion of value, the property needs to be sold for at least 90% of the court referee's opinion of value. So the court referee will come out with their opinion of value. The real estate agent will put the property on the MLS and market the property, and they'll accept an offer. And usually they want to accept an offer that is 90% of the court referee's opinion of value. Once they do that, they'll go to the attorney, and they will tell the attorney to get the court date set. Once their attorney gets the court date set, the real estate agent will keep marketing the property and let people see the property, let them do their due diligence. If they want to pay for an appraisal or whatever they're going to do, the real estate agent will allow them to do that and continue to market the property. And they'll promote it so that everyone knows about the court confirmation sale. In the confirmation hearing, it's kind of like an auction. The judge says the property up now is 123 Main Street. The accepted offer is this amount, and who's going to overbid? The next overbid is X dollars amount. So let's talk about how that works a little bit. The accepted offer will come in. Usually the next overbid will be roughly about 5%. I have some other documents. You can look on my website, probatetitle.com, and find some other documentation to find out exactly how you determine the overbid price, because they have a guideline in the probate code or in the county process. But besides that, you're typically looking at 5% above the accepted offer price will be the first overbid. And a lot of times they'll go in $500 increments above that. They'll go in the auction. The confirmation hearing is like, in the court, the confirmation is like an auction. They'll specify their overbids. Once they get a final bid, the judge will bring down the gavel and say the property is sold for that value. Now, the successful bidder needs to know a couple things. Number one, it's a no contingency sale. So it's not subject to appraisal. It's not subject to lender approval or termite or inspections. So they need to be ready to go, and they need to have their cashier's check right there on the spot. Roughly about 2 weeks after the sale is done, they will have the judge sign the court order. The court order will be approved and signed, and then they can go ahead and close escrow at that point. As always, consult your own legal and tax professionals for advice. To reach me, Kevin Sales, probatetitle@gmail.com or 213-364-3810, and find me on the web at www.probatetitle.com.